and to thank you all of our presenters. And we appreciate all of our attendees who are staying for this Q&A session. If you would like to ask a question, go ahead and type it into the Q&A pod, and we're going to go ahead and get to as many questions as we can in the time that we have. So with that, we'll go ahead and get started. Our first question is for Dr. Chen. So the question is, when FDA forwards a patent dispute to the NDA patent holder, does the originating party remain anonymous, or is the name of the person company?
Thank you for that question. So when the FDA receives a patent dispute, the intent of the whole process is for it to be anonymized. However, I do want to point out that what that will depend on is how well the original disputer has put together that statement of dispute. So one of the items that we've kind of given as a tip is that if you want to submit a patent dispute to the NDA holder, submit the statement of dispute as an attachment to your email to the Orange Book mailbox. And the Orange Book mailbox is orangebook@fda.hhs.gov. And then when you do that as that statement of dispute in a separate document, make sure that you remove any identifying information in that attachment. And so I just wanted to reiterate that for the statement, for the disputes, that the FDA sends the text of the statement of dispute to the NDA holder without review or redaction.
Great, thank you. We have another question for you. So the question is, typically for the statement of disputes for a patent dispute submission, what information is included? Should the correspondence contain technical and legal details regarding why we believe the patent should not be?
Thank you for that question. So I won't speak to giving any specific advice about what the dispute should contain. In terms of the agency's role in the patent disputes, similar to the patent listings, our role is ministerial. So in terms of that dispute communication, the statement of dispute should describe the specific grounds for disagreement regarding the accuracy or relevance of the patent information for FDA to send to the applicable NDA holder.
Great, thank you. And we have one more question, and then after that we'll go to Lieutenant Commander Coogan. So on the FDA Forms website, the instructions for filling out the Form 3542 exist, but not the Form 3542 itself. Where can companies download the 3542?
Sure. This is a good question, and we'll get this question now and then. So the best way, if you go to the FDA Forms website, there's a search bar there, and when you type it in, what you should use as a search criteria is just the numbers 3542. And then when you do that, you'll get 4 hits. It'll be 23542A documents and 23542 documents. So that should get you to the actual Form FDA 3542 as well as the supplement.
Great, thank you. All right, our next question is for Lieutenant Commander Coogan. When the RLD revises their use code, is there a deadline to recertify and
So there is not a deadline to recertify or renotify. However, the agency will not issue a final action, whether it be tentative approval or full approval, depending on the other regulatory situations surrounding the application. They won't take an action on that until the patent information has been adequately addressed, which includes recertifying, renotifying. So there is not a deadline. However, your application will not be eligible for final action until you adequately address the patent information. And if there is a requirement of recert or renote, that would need to be handled before you could receive a patent.
Great, thank you. Another question for you. What is the difference between a paragraph 1 and no relevant patent certification? Are there situations where a paragraph 1 certification would be required over a no relevant patent certification?
There is not. The no relevant patent statement versus the P1 certification are, for the most part, interchangeable. If there are no patents listed for an RLD, you can use either one, and there's not any reason that you would have to use one over the other.
Okay, great. And another question for you. If an ANDA sent a P4 certification non-infringing to the NDA holder and the ANDA applicant was not sued, no 30-month stay, can the NDA holder file a lawsuit against the ANDA applicant in the future?
The NDA holder, that is the RLD, could file a lawsuit. However, there would be no stay of approval. And if there's no stay of approval with regard to a paragraph 4 certification, there would be no reason for the agency not to issue an action. However, if ultimately the applicant loses on that patent litigation, the agency would rescind the final action letter. However, with regard to the stay of approval, there would be no stay of approval if litigation is filed outside the 45 days. However, it is possible that a RLD could initiate litigation outside that period.
Great, thank you. Our next question is for Marianne. So, Marianne, is the once a B2, always a B2 rule new? I recall seeing some supplements treated as B1s even if the underlying application was a B2.
Hi. No, the once a B2, always a B2 rule is not new. The thing is that even if you are submitting perhaps a whole new clinical study for your supplement and you are originally a B2, you are still relying upon the underlying information that you originally relied upon with your original NDA. So that B2 supplement, even though you maybe have it's composed entirely of your own clinical information, is still relying upon the information that your original B1, your original B2 application relied upon. So no, that rule is not a new rule.
Thank you. We have another question for you. Can you elaborate on what is meant by maintaining patent certifications to a pending B2 application?
Yeah, okay. To maintain your patent certifications to your pending B2 application, you need to constantly be monitoring the Orange Book to provide additional information to any new timely filed patents that are relied upon on your relied upon listed drug while your B2 application is pending. You must also monitor the Orange Book and address any new claims, as Andrew discussed in his presentation, that are listed on the patents for your relied upon listed drug. For instance, if the listed drug obtains approval for a new indication and adds a new additional method of use code to an already listed patent, you will need to address the newly listed method of use code on the patent for which you've already provided a patent certification.
Great, thank you. We have another question for you. If there are no listed patents on the listed drug relied upon for my 505(b)(2) application, how do I know which patent certification to provide?
But it's up to the applicant to provide the appropriate patent certification or statement. If there are no unexpired patents on the listed drug, then no relevant patent statement, a paragraph 1 or a paragraph 2 patent certification may be appropriate. But the applicant must decide which statement or certification is most appropriate and then provide that.
Great, thank you so much. And our next question is for Dr. Chen. Dr. Chen, if I submitted a patent dispute, but it hasn't yet shown up on the patent dispute list, what could be the reason for the delay, and how can I find out when my patent dispute will be updated to the patent dispute list?
Thank you for the question. So this goes back to the timeline of the patent dispute list. So because the disputes are updated on a monthly basis with the Orange Book monthly cumulative supplement, the earliest that a dispute will show up in the applicable monthly update for the chart is with the monthly CS. And then in terms of the timing of why there might be a delay for it to go up for whatever reason, it's also possible that there's an outstanding request from the agency that we're waiting on before we're able to process it. So if you think back to the requirements under 314.53 F1 for the changes, the corrections to patent information by agents other than the NDA holder, that if, for example, a method of use dispute was submitted with a statement of dispute that's, say, 300 words rather than that limit of 250, it would need to be sent back and revised and then resubmitted to the agency. And then preferably, like I mentioned before, the submission of the statement of dispute would be attached as a separate document to the email.
All right, great, thank you. Another question for you. Can an ANDA filer request for patent delisting?
Yes. So the short answer to that is yes. And in terms of going back to one of the prior questions that we had regarding how to remain anonymous, those best practices still apply here. So in terms of requesting for patent delisting, what they could submit it as is a patent listing dispute. And then the ANDA filer would need to follow those requirements outlined in 314.53 F1.
All right, thank you. Our next question is for Lieutenant Commander Coogan. So the question is, if an FDA filing date falls on a Saturday, Sunday, or a holiday, does the due date roll to the next business?
So I assume this means the 20th day after the acknowledgement for filing letter is sent, and in that case, the 20th day, if it falls on a Saturday, Sunday, or federal holiday, it does move to the next day that is not a Sunday, Saturday, or federal holiday. And if you look in the CFR under sending the notice, it does outline how to deal with these types of situations where the 20th day after the acknowledgement for filing letter falls on a weekend or federal holiday.
Thank you. Another question for you. How can an ANDA applicant tell whether patents listed in the Orange Book were timely filed?
So if you look at the online version of the Orange Book, there is a column for patent information submission date. Based on that submission date, that's the date that the information was submitted to the agency. You can compare that to the date that the patent was issued by the U.S. Patent and Trademark Office, or the date that a latest supplement was approved for the RLD, and comparing that date to those relevant dates, you can determine whether or not the patent was timely filed.
Thank you. Another question for you. If my firm has provided a paragraph 4 certification to a patent that has pediatric exclusivity and that has expired, do I need to update my patent certification?
No, you do not. Once a patent expires that has pediatric exclusivity, your paragraph 4 automatically becomes a paragraph 2, and you are in that pediatric window and are unable to be finally approved until the pediatric exclusivity expires. So there's no action required on the part of a applicant to update their patent certification from a paragraph 4 to a paragraph 2.
Okay, another question for you. Are companies required to notify FDA of litigation if they are sued on a paragraph 4 certification for a patent listed after they've received their P4 acknowledgement?
So if an applicant addresses a newly listed patent and are sued on that, they are not required to notify us if they were sued. However, if there is any final decision issued in that case, they will be required to notify us of that. However, if the complaint is either amended to an original complaint or new litigation is filed for a newly listed patent, they are not required to notify the agency.
All right, and another question for you, and our next question will be for Mary Ann. Are we required to notify FDA of marketing of an authorized generic if they've withdrawn an ANDA that previously was the first filer?
So if an ANDA applicant is no longer the first filer, meaning they have withdrawn their application or they have amended a paragraph 4 certification to paragraph 3 certifications, or if, let's say, the patent that they had previously provided paragraph 4 certification had expired, 180-day is no longer a factor, and they would not be required to submit notification of commercial marketing. But if they are a first filer and have not forfeited or waived, or the 180-day exclusivity is not expired, then they would require to submit notification of marketing within 30 days.
Great, thank you. And this next question is for Mary Ann. Can a 505(b)(2) prescription applicant rely on a product that was a prescription to OTC switch? Is a 505(b)(2) application required to rely on a product with the same strength of an active ingredient, or can they select another product with a different strength as the listed drug?
Okay, thank you for that question. A 505(b)(2) application may rely upon a product that has been switched from prescription to OTC. One thing that you would need to keep in mind, though, is the boundary of what you can rely upon is within the approved labeling, and the OTC labeling may not include all of the information that you may possibly need to rely upon, so you may need to do some studies on your own. However, if you can get all the information that you need for your application from the OTC label, then you could most certainly rely upon an OTC drug product. And then the second part of the question about a B2 application being required to rely on a product with the same strength as the active ingredient. A 505(b)(2) application does not have the sameness requirements that a generic application would rely upon. So a B2 application can rely upon any approved listed drug that was approved under Section 505B under the Federal Food, Drug, and Cosmetic Act. The thing is that they need to be able to provide a bridge, which is beyond the scope of today's discussion. So as long as they can bridge to that listed drug that they wish to rely upon, then they can rely upon a drug that is different from their own, from a different strength from their proposed product.
Great. Thank you, Mary Ann, Alicia, and Andrew. And as well, thank you to Jennifer for joining and helping